So we're going to start off with Julie Tyus, who's going to tell you things about child support and how you can get in trouble, followed by Tim Dietz, who's going to tell you about how spousal support is not just a simple calculation. There's a lot of things to think about. I'm going to talk about children's issues. Maybe shut that down and talk a bit louder. And some of what's going on with children's issues now in the court, so you have an idea of what might happen to someone in family court who has a custody access issue. After that, we have Todd Slonum, who's going to explain to you why you don't necessarily have to go to court anymore if you want to get separated or divorced. There are other options, and many of them may be better for you or your clients or whoever you're trying to help out. And finally, we're going to have Rachel Healy. She's going to explain to you why writing a separation agreement on your kitchen table on the back of a napkin probably not going to get a lot of attention from the court and might get you into bigger fights down the road.
And many of you probably think this is going to take 2 minutes because I'm just going to tell you the higher income earner is going to pay a table amount of support to the lower income earner, and that's it, and I'm leaving. But that's not the case. There's actually a lot more complexity to child support in terms of who's paying, how much they're paying. So who pays child support? Well, very simplistically, when parents separate, the parent who's not living with the children must pay child support to the parent with whom the children reside. Usually, child support begins when the parents physically separate. So when one parent moves out of the home, leaving the children and the other parent in the home, or when they sell the house and they each go to different residences, or when one parent leaves and takes the children with them. That's usually when the clock starts ticking. Parent, of course, means natural parents, biological parents, but also adopted parents. And as you probably know, many of you, child support is governed by the federal and provincial child support guidelines.
And to obtain a divorce, you had to prove cruelty or adultery on the part of your spouse. For a wife to obtain support, again, she had to prove cruelty, adultery, or desertion by her husband. For a husband to obtain support, he had to move somewhere else. It simply wasn't available in Canada. And the idea behind this was that marriage was viewed as a lifetime contract under which the husband agreed to provide lifetime economic support to the wife. And the only way this obligation would end would be if one of the parties broke the contract. In the case of the wife, again, through her adultery, cruelty, or desertion, and the same with the husband. For the wife to obtain support, and if she was successful in proving the adultery or cruelty, she would receive support, and the principle was that she would receive lifetime support in an amount that would allow her to continue with the same standard of living that she enjoyed during the marriage, which, if you think about it, is really kind of difficult. You have one household with one standard of living, you split it into two households, but you want the one household with the wife to maintain the same standard of living, which leaves the husband somewhere else.
Talking about children in separation and divorce and where we're headed now in the legal landscape. This is a presentation on a really big topic that people spend a lot of time in court on. And so I'm going to be going over these things fairly quickly and sort of brushing over them so you get a bit of a general idea. If you need more information, I have done this as a much longer, as in a 2 hour plus seminar. And those are recorded and they're now podcasts on our website. So if you go to devrylaw.ca and you go to the podcast under resources, there's podcasts on child support or child custody issues and how children's voice and how courts look at both of them. There's also a lot of information there to look it up. But if you're into a complex child custody access situation, best thing to do is, of course, talk to a lawyer. Now, I'm going to, in the next 20 minutes, go over some of the hot topics, such as what does child custody mean? Because a lot of people get that wrong. Why do people think it matters? Because most people think it matters for the wrong reason. What is the difference between sole, split, and shared custody? Again, because that can be important, as Julie said, with regard to support, but also in terms of how you organize your life, and how courts decide between those three options. I'm also going to go briefly over who makes the decision over sole, shared, split custody. Is it the judge? Is it the social worker? Is it the parents? And finally, how do we hear what kids want, or should we hear what kids want, and does that even matter to anybody?
Separation and divorce is a complex process. Most parties prefer to obtain efficient results and want to avoid protracted litigation. Parties are looking for alternatives to court to resolve their matrimonial disputes. Parties who focus on cooperation between each other advance a commitment to insulate the children from negative outcomes. Let's take a look for a moment at private negotiations between parties. This is where parties discuss between themselves their needs and concerns and look at ways they can resolve in hopefully a positive way. This often happens around a kitchen table, and this is why it's called often as kitchen table negotiation. This discussion can be used as a framework for a comprehensive agreement, i.e. moved into a more formal agreement known as a separation agreement. Problems with this is that parties, of course, are not family law lawyers. They may not appreciate their legal rights. And if children are involved, and most critically, the settlement terms need to be fluid, reflect their ages, stages of development. This is why you actually do need family law lawyers in this process. And we're going to take a look at next what will happen.
Talking a little bit about domestic contracts, which piggybacks very nicely on Todd's presentation, primarily because when you are working in an alternative dispute resolution process, so anything other than court, what your main goal is generally to come up with what's called a domestic contract. So, what is a domestic contract? Part 4 of the Family Law Act is the legislation that governs all domestic contracts. They are defined under Section 51 of the Family Law Act as either a marriage contract, a separation agreement, cohabitation agreement, a paternity agreement, or a family arbitration agreement. I'm going to be focusing primarily on the first 3 of those, primarily because they're the ones that we see most often, and for time constraint purposes, they make most sense to deal with together. So, there we go. So the enforceability of domestic contracts, or as John mentioned earlier, can you sit down at a kitchen table and write out a domestic contract on the back of a napkin? Sure, if you don't want the contract to be worth the paper that it's written on. Not all domestic contracts are enforceable, and this is news to a lot of parties that come to see us. Just because 2 parties agree on the terms of a contract doesn't mean that a court is going to enforce it. There are strict rules which must be followed to ensure that domestic contracts are enforceable. That's what I'm going to go into shortly. And it's important to note that these requirements are set out in statute, but also they're also clarified and refined by the case law. So you should be familiar with both if you are advising anyone on a domestic contract.